Kembali kami himbau kepada para hadirin sekalian yang telah melakukan registrasi untuk dapat menempati tempat duduk yang telah kami sediakan. Karena dalam waktu sesaat lagi kita akan memulai acara pada pagi hari ini. Selamat datang kami ucapkan kepada Rektor Universitas Islam Riau yang telah memasuki ruangan beserta dengan keynote speaker pada acara kita pada pagi hari ini beserta jajaran tamu undangan sekalian. Oleh karena itu marilah kita berikan tepuk tangan yang meriah kepada Rektor Universitas Islam Riau sekaligus keynote speaker dari acara kita pada pagi hari ini yang telah memasuki ruangan auditorium Universitas Islam Riau. Bismillahirrahmanirrahim. Jari bersusun mengatur sembah, sanggul berhias bunga dahlia. Tari persembahan tepak bertadah menyebut majelis jemputan mulia. Hadirin berbahagia, dengan bangga sebagai pembuka, marilah kita saksikan tari persembahan.
Makan sirih, tepak Melayu Tuhan, lambanglah ada pusaka Melayu. Makanlah sirih, ujunglah ujungan, ujungan, ujungan. Sirih dimakan, hai beserta saja. Makanlah sirih, ujunglah ujungan, aduhailah sayang. Sirih dimakan, Selamatlah datang, hai kami ucapkan, aduhailah sayang. Kepada Tuan Cik Puan Budiman, selamatlah datang, hai kami ucapkan, hai makanlah sirih. Kepada Tuan Cik Puan Budiman, makan sirih mengundur diri Tuan, salah dan silap maaf diberi. Makanlah sirih Tuan Budiman, makanlah sirih Tuan Budiman. Sirih dimakan ujung-ujungan, sirih dimakan ujung-ujungan. Makanlah sirih adat Melayu, makanlah sirih adat Melayu. Lambang dan adat pusaka Melayu, lambang dan adat pusaka Melayu. Makanlah sirih Tuan Budiman, makanlah sirih Tuan Budiman. Sirih dimakan ujung-ujungan, sirih dimakan ujung-ujungan. Makanlah sirih adat Melayu, makanlah sirih adat Melayu. Lambang dan adat pusaka Melayu, lambang dan adat pusaka Melayu.
Bujang Melayu gagah perkasa, gagah perkasa jangan disentuh. Kata salam sebagai pembuka, Assalamualaikum warahmatullahi wabarakatuh. First and foremost, let us begin this special occasion with a moment of gratitude and praise. We thank God Almighty for His endless blessing, guidance, and grace that have brought us together today. And without His dividend providence, none of this would be possible. And of course, let me welcoming all of you to our main event today, the first Hybrid International Conference on Law and Social Science 2024, live broadcast from Universitas Islam Riau. Our event today is made even more special by the presence of several esteemed guests. Kindly join with us, extending me a warm welcome to Rector of Universitas Islam Riau, Profesor Dr. Syafrin Ladi, SIMCL, knowing also as one of our keynote speaker for our today's event, Vice Rectors of Universitas Islam Riau, and also to postgraduate directors, Professor Dr. Detri Karya SEMA, and also to Chief Executive of ICoLSS 2024, Professor Dr. Elidar Haidir, SHM, knowing also as one of our speakers, beside with Pak Rektor Universitas Islam Riau. And also a warm welcome we express to our keynote speakers that has joined for our today's event, Associate Professor Dr. Abdul Talib from Universitas Islam Riau, Indonesia, Professor Dr. Stephen Kus, the Universität der Bundeswehr München from Germany, Professor Kim Hyun-so, PhD, from Ina University, South Korea, Nola Fibriani, BTS Salma, PhD, from Muhammadiyah Islamic College, Singapore, Dr. Yusra Miza, from University Utara Malaysia, Professor Yuzuru Shimada, PhD, from Nagoya University, Japan, and our gratitude to the Dean and the Faculty of Universitas Islam Riau, the head of departments, the chairs of institutes, the directors, and to the all academic community from the Islamic Universitas Islam Riau who have joined with us recently. For more information, this event is also being broadcast live on YouTube channel Universitas Islam Riau and also via Zoom applications. Well, ladies and gentlemen, I'm Yusuf Rafli, and I'm so honored to be your master of ceremony for our today's event. Before we start the agenda, let's see the video of safety guidance in the auditorium of Universitas Islam Riau.
Welcome to the Islamic University of Riau. We will provide safety guidelines for this building. Currently, you are in the auditorium on the 4th floor of the Rectorate building. This room is equipped with smoke detectors that will react when the smoke density exceeds the predetermined threshold. Therefore, smoking is prohibited in this room. The smoke detectors also function to detect the temperature of the smoke, reacting if the room temperature exceeds 50 degrees Celsius and in case of a fire indication. Additionally, this room is equipped with 3 fire extinguishers, one hanging on the rear wall of the room, one on the front wall to the left of the podium, and one on the outer wall of the room. The seating capacity of this room is 292 seats, with 2 main doors located at the back and 2 additional doors on the right side. This building also has 4 toilets, 2 outside the room next to the elevator and 2 behind the main podium inside this auditorium. We need to inform you that the potential hazards in this building are fires and earthquakes. Please familiarize yourself with the environment to anticipate these potential dangers. In case of a fire, you're requested not to use the elevator for safety reasons. Our staff will direct you to the emergency stairs and the assembly point located in the front left parking area outside this building. In case of a power outage while you are in the auditorium, please turn on the flashlight on your mobile phone to help with lighting. If you are in the elevator, please do not panic. Press the yellow emergency button and we will provide assistance immediately. If you hear the alarm sound, it indicates a real emergency. In the event of an earthquake, please find the emergency exit and do not use the elevator. Use the emergency exit in an orderly manner and do not run. If the emergency exit or exit door is blocked by fire and there is no other way, pull down the curtain rope to open the glass curtain and break the glass as much as possible with any tools available around you, and do not use your body parts. Thank you for your attention. Enjoy your activities.
Singing the national anthem of Indonesia, Indonesia Raya. To all audience, please stand up. please have a seat. Thank you. Before we begin formal, let us listen to the recitation from the Holy Quran and a prayer by Muhammad Faisal. The time is yours.
Assalamualaikum warahmatullahi wabarakatuh. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. شهد الله أنه لا إله إلا هو والملائكة وأولو العلم قائما بالقسط. لا إله إلا هو العزيز الحكيم. إن الدين عند الله الإسلام وما اختلف الذين أوتوا الكتاب وما اختلف الذين أوتوا الكتاب إلا من بعد ما جاءهم العلم بغيا بينهم. ومن يكفر بآيات الله فإن الله سريع الحساب. ومن يكفر بآيات الله فإن الله سريع الحساب. صدق الله العظيم. صل وسلم وزد وبارك على رسول الله وآله الأطهار على رسول الله وأصحابه الأخيار. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. الحمد لله رب العالمين حمد الشاكرين حمد الناعمين حمدا يوافي نعمه ويكافئ مزيده. يا ربنا لك الحمد ولك الشكر كما ينبغي لجلال وجهك الكريم وعظيم سلطانك. اللهم صل وسلم على سيدنا محمد وعلى آل سيدنا محمد. اللهم اغفر لنا ذنوبنا ولوالدينا وارحمهما كما ربيانا صغيرا، ولجميع المسلمين والمسلمات والمؤمنين والمؤمنات الأحياء منهم والأموات، إنه سميع قريب مجيب الدعوات ويا قاضي الحاجات. اللهم قسم لنا من خشيتك ما تحول به بيننا وبين معصيتك، ومن طاعتك بما تبلغنا به جنتك، ومن اليقين ما تهون به علينا مصائب الدنيا. اللهم متعنا بأسماعنا وأبصارنا وقوتنا ما أحييتنا، واجعله الوارث منا، واجعل ثأرنا على من ظلمنا، وانصرنا على من عادنا، ولا تجعل مصيبتنا في ديننا، ولا تجعل الدنيا أكبر همنا ولا مبلغ علمنا، ولا تسلط علينا من لا يرحمنا. اللهم إنا نسألك علما نافعا وعملا متقبلا ورزقا حلالا طيبا مباركا فيه. ربنا تقبل منا إنك أنت السميع العليم، وتب علينا إنك أنت التواب الرحيم. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار. وصلى الله على سيدنا محمد وعلى آله وصحبه أجمعين. سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين. السلام عليكم ورحمة الله وبركاته.
Ladies and gentlemen, the next agenda, that is the opening speech from the Chief Executive of ICoLSS 2024, Professor Dr. Elidar Haidir, SHM. The time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning. Peace be upon us. Alhamdulillah, thanks to Allah subhanahu wa ta'ala for the abundance of the blessing and gift. Today we are together in auditorium Rectorial Universitas Islam Riau in the event of international seminar with theme Law and Social Science for Sustainable Development, navigating challenges and opportunities in achieving the Sustainable Development Goals. Honorable audience, I would like to report this international seminar activities attended by 26 domestic universities and 7 foreign universities, which total 112 participants. Several overseas composition participants are from Malaysia, Singapore, Germany, Korean, and Perlis. This international seminar will be held to hybrid system. The call for paper session will be held after Friday. Friday will be ready in the afternoon. Then I would like to thank to all keynote speakers who takes a part of presenter at international seminar organized by Universitas Islam Riau. The speaker that follows the offline activities are from Kim Hyun-soo, PhD in Hai University, Korea, South Korea. As keynote speaker, Dr. Yusramiza, Notable University of Malaysia, and Dr. Haji Abdul Talib, SIMCL, Universitas Islam Riau. Next, thank you to Mrs. Nola Febrianti binti Salman, PhD from Muhammadiyah Islamic College, Singapore, and for Professor Dr. Stephen Koos, the University der Bundeswehr Munich, Germany. Professor Yuzuzu Shimada, PhD, Nagoya University, Japan. Thank you to honorable keynote speaker who take part with us the international seminar activities today dedicated for more, we would like to thank all parties who have dedicated to making international seminar possible. Hopefully, this international seminar activity will contribute for all parties. Finally, I close my report. Assalamualaikum warahmatullahi wabarakatuh.
Thank you to Professor Dr. Elidar Khaidir SAEHUM for the opening speech as the Chief of Executive of ICoLSS 2024. Ladies and gentlemen, let's move on into our next agenda. That is the welcoming speech from the Postgraduate Director of Universitas Islam Riau, Professor Dr. Detri Karya SEMA. Time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. His Excellency, our Rector, Professor Saprinaldi, Professor Dr. Elidar Khaidir, Dr. Abdul Talib, Professor Kim Hyun-soo from Inha University, South Korea, Professor Dr. Yusra Miza from University Utara Malaysia, Professor Stefan Koos from the Universität der Bundeswehr München, Germany, Prof. Yazuru Shimada from Nagoya University, Japan, and Nola Febriani from Muhammadiyah Islamic College, Singapore. First of all, let us thank God, the Almighty, who has given His grace and guidance so that the International Conference on Law and Social Science, or ICoLSS, can be held successfully. I welcome all of you to the seminar, which has received great attention not only from the university, but also from law and social sciences work communities to submit papers to be presented in this seminar. I'm also pleased to acknowledge the support we have received from our keynote speaker and guest speaker for this conference. I appreciate the keynote speaker, Professor Kim Hyun-soo from Inha University, South Korea, and also Professor Stephen Koos from München University, from München, Germany, and Professor Yezuru Shimura from Nagoya University, Nola PhD from Muhammadiyah Islamic College, Singapore, and Associate Professor Dr. Yusra Miza Yusuf from University Utara, Malaysia. Thank you for your accepting to be a part of this conference. Last but not least, I would like to appreciate all the scholars who have taken time to prepare submission for this conference. We also choose this conference as the platform of disseminate your valuable research outcomes. As researcher university are core components of any country economics, political, and social development system. If knowledge for augmenting productive power is necessary, research is the fundamental process and the institutionalization which produce research and further research. Great care has been taken to ensure that you have a very rewarding experience during your presentation. I believe that this seminar will be the source of innovative idea, concepts, and breakthrough the development of law and social science in the future. And also, seminar will not be organized without the support of various parties, especially from all of us. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you once more to Professor Dr. Detri Karya SEMA for the opening speech as a postgraduate director of Universitas Islam Riau. Next move on is the welcoming speech from rectors of Universitas Islam Riau, Professor Dr. Syafrinaldi, SH MCL. The time is yours.
Before I begin the speech, I would like to present you pantun. Pulang kerja di waktu petang, minum kopi di pagi hari. Kepada hadirin kami ucapkan selamat datang, kami sambut dengan senang hati. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin wassalatu wassalamu sarfil anbiya'i wal mursalin wa ala alihi washabihi rasulillahi ajma'in. Asyhadu an la ilaha illallah wa anna Muhammadar Rasulullah. The distinguished guests that I would like to call Ketua Umum the chairman of our foundation, Professor Dr. Nurman, and also the daily chairman, Bapak Zulfikar Ahmad, respected vice rectors, the deans, and director of postgraduate program, the high officials ranks at Universitas Islam Riau are joining this program today. And ladies and gentlemen, especially our keynote speakers, they are Professor Dr. Stefan Kos from Germany. Thank you very much. As we know, it's of course a difficult time for you now because in Germany it is around 3 o'clock a.m. in the morning. Professor Stefan Kos is one of our best friend of mine, and we are very happy to welcome you. Professor Kim Hyun-soo from Inha University, South Korea. Thank you so much for coming. It's the second visit of him to our university. I want to thank also Professor Yazuru Shimada, PhD from Japan, Nagoya University. Thank you to Dr. Yusra Mirza Yusuf from UUM, University Utara, Malaysia. I thank you also Dr. Nela Fibriani bin Salma from Muhammadiyah, Singapore, and our dear colleagues, Abdul Talib, PhD from Universitas Islam Riau. Good morning, everybody. It's with great pleasure and honor that I welcome you all the audience and participants, to the first Hybrid International Conference on Law and Social Sciences. This gathering brings together some of the brightest minds from around the world, united by a shared passion for advancing knowledge, fostering collaboration, and addressing the pressing challenges of our time. First and foremost, I would like to extend my deepest gratitude to our keynote speakers, to the organizers, and all the people who are preparing this event very well. This conference comes at a vital moment as we navigate through an era marked by rapid technological advancements, global interconnectedness, and unprecedented challenges. The importance of coming together to share insights, ideas, and solutions about law and social sciences, like cyber law, AI, IPR, risk management, etc., cannot be overstated. We are privileged to have with us an extraordinary lineup of speakers who are leaders and experts in their respective fields. Their expertise and experiences will undoubtedly provide us with valuable perspectives and inspire us to think differently about the issues we face. But this conference is not just about listening. It is about engaging, questioning, and collaborating. I encourage each of you to take full advantage of these opportunities to interact with your peers, challenge conventional wisdom, and forge new partnerships. The exchange of ideas that will occur in this space is lifeblood of innovation and progress. As we embark on this journey together, let us keep in mind the broader impact of our work, the knowledge we share, And the connection we build here have potential to drive meaningful change, not only within our professional communities, but also in the wider world. I would like to reiterate my heartfelt welcome to each and every one of you. Thank you for being here, for your commitment to excellence, and for your contributions to this vibrant and dynamic field. I am confident that this conference will be a rewarding experience for all, filled with inspiring discussions, groundbreaking ideas, and lasting memories. Thank you very much for the organizing committee, especially all the professors of Universitas Islam Riau. Thank you for Professor Aidar Khidir, who is the chairwoman of this event, and all the participants coming from all over Indonesia and many countries. Let us now officially begin the first Hybrid International Conference on Law and Social Sciences. Bismillahirrahmanirrahim. May Allah subhanahu wa ta'ala bless us. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much to Rectors of Universitas Islam Riau, Professor Dr. Syafrinaldi SH MCL. And then we're gonna proceed to our next event. That is the keynote speech to be delivered by the Professor Kim Hyun-soo, PhD from Ina University, South Korea. To Professor Kim, the floor is yours.
Thank you, invite for a very nice place. I think a very nice and beautiful in Pekanbaru in Indonesia. My keynote speaking is titled is Navigation the Intersection of AI and Criminal Law. Ladies and gentlemen, it is an honor to address this distinguished assembly today as we dive into one of the most impressive issues of our time. The intersection of AI and criminal law, and we stand at the dawn of the fourth industrial revolution. We find ourselves on the brink of the profound changes that challenge the very foundation of our legal and social system. AI is defined as a subfield of computer science that artificially implements human learning, reasoning, and perceptual evidently, thereby realizing human intelligence in the machines. Currently, AI is used in criminal procedures, but our concern goes far beyond this. I have a privilege of teaching criminal law in South Korea, a field traditionally known for its conservative approach. Criminal law has aimed to protect human diversity and answer freedom. Yet, the pace of the social change, driven by technological advancements, is outstripping our ability to adapt. Today, we live in a world where smartphones are indispensable, and the notion of a society without them is incensurable. When we wake up in the morning, the first thing we research for is our smartphone. How about you? No? Where is my smartphone in the morning? No? Everybody? No? It's only one? When we this rapid transformation, the centuries of revolution of our approaching to criminal law and broader domain of social science. In particular, the advancement of AI has become the catalyst for society change. AI has evolved from the beginning of tool controlled by human to entities capable of making independent decisions. This shift presents a doubting scenario where human control might become untenable. Steven Spielberg's film AI. Are you watching the AI movie? Yeah? Yeah, okay, thank you. Yeah. Steven Spielberg's film AI comes to mind, depicting a future where robots liberating a debatation Earth. The film explored whether love between human and robot is possible. We must acknowledge that such a future is not as distant as we might think. Traditionally, social science have led social change. However, they now seem to seek stability rather than development. Failing to keep pace with technological advancement, fields such as law, public administration, and humanities are at risk of stagnation. My focus, criminal law, has historical certainty on understanding how crime are constituted and how to punish perpetrators. However, in advance of the AI rise, new questions that challenges traditional notion of crime. Can only humans be subject of crime? And is punishment limited to humans? Consider the possibility of embedding human ability into the machine, creating human surrogates. If an AI commits a crime, should we arrest it? Presently, this is not feasible because AI is not considered human. Our certain definition of crime, which view human acts violating social norms as crime, and cannot accommodate this future changing. To control AI, scholars have turned to ethical principles from philosophical perspective. However, The time for ethical judgment on AI crime has passed. We need stronger control measures, and AI must be firmly under human control. Criminal law must now address whether AI's acts can be deemed criminal. This is our responsibility as researchers. Today's criminal law, based on the act responsibility, presupposes the ability to act. If AI act ability is not recognized, discussing AI's criminal responsibility is meaningless. Ultimately, the issue of AI and criminal law boils down to how we control AI. We must decide whether to prevent AI's criminal acts and impose self-pretentry on the penalty on the AI for committing crimes. What path should we choose? Do we need strong regulation to prevent AI's criminal acts, or punishment for AI's criminal acts? Preventing AI's criminal acts for within the moral and philosophical realm, while punish AI's acts is a legal matter, especially within criminal law. AI independently decides to commit anti-social acts and harm humans. We must focus on the logic that such decision by AI can be evaluated of the action deserving punishment. Our society is interconnected through network, creating another layer of the social to meet human need. In theory, this network serves humans, but we must recognize that in the future, humans might become tools of the network. This is transactions national borders. It affects countries globally, from Indonesia and Malaysia to South Korea and beyond. In this global era, discussions on the need for the legal paradigm shifted to march in the pace of AI development through the commerce today here in Pekanbaru. We need to have realistic discussions for the sake of a future generation. I wish for the successful hosting of this international conference today. I would also like to take this opportunity to sincerely thank everyone who prepared for this international conference, and especially President Dr. Shafrinari for inviting us to the wonderful city of Pekanbaru. As a final thought to conclude the keynote speech, let me say this. If there's a will, there's a way. Thank you very much. Shukran. Terima kasih.
Thank you once more, we say to Professor Kim as the keynote that already been delivered to us today. And then so on, we will be focusing to our main event today. That is the seminar from the 5 more speakers that has joined with us today in our Zoom meeting and even more in our Auditorium Universitas Islam Riau. And because of that, from this point forward, the event will be fully moderated by the Associate Professor Dr. Sri Yuliani SPD MPD. And because of that, please join with me in welcoming the moderators for our main event today. Associate Professor Dr. Sri Yuliani SPD MPD. And once more, let us give the big applause to our moderator today, Associate Professor Dr. Sri Yuliani SPD MPD.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Morning all. How are you? Okay, thank you. The Honorable Prof. Nurman as the head of YLP Riau and staff who attend in this meeting. The Honorable Rector Universitas Islam Riau, Professor Dr. Safrinoli Esamsial, and together with Vice Rector 1, 2, and 3, the Honorable Chairman of this international seminar, Professor Dr. Elidar Haidir. Thank you, Bunda. And respectable keynote speaker, Prof. Kim, and also the invited speaker from Muhammadiyah Islamic College Singapore, Ibu Nola Febriani. Then this offline today, Ibu Dr. Yusra Miza from University Utara Malaysia, and Professor Dr. Stephen Kos from München, Germany. Then Dr. Abdul Talib will be here offline. Later I will call you to be invited in this stage. And then from Universitas Islam Riau, yeah, Dr. Abdul Talib. Then the last is Professor Yuzuru Shimada from Nagoya University, Japan. And thank you for all the higher officials from Universitas Islam Riau, Dean, and all the staff here attended in this evening, this morning, and all the participants and audiences. Let me introduce myself. Okay, I think some of you maybe knows me, but some other don't know, especially for the keynote speaker. Yeah, Ibu, yeah? Okay, my name is Sri Yuliani. You just call me Mem Sri. This is a usual name, common name in my area, in UIR especially. And then it gives me a great pleasure to be the moderator, to lead this invited speaker on this international seminar, ICoLSS, with the theme Law and Social Sciences for Sustainable Development, Navigating Challenges and Opportunities in Achieving the Sustainable Development Goals. All right, now is the turn to call the invited speaker. I welcome I welcome Ibu Dr. Yusra Miza from University Utara, Malaysia. Please come to the stage, Ibu. You may sit any place. Okay, please have a seat. Next, I call Bapak Dr. Abdul Talib. Please promote to the stage, Pak. Sekarang saya duduk. Tadinya duduk. Takut jatuh. Nanti bisa berdiri. Boleh, boleh. You may sit. Before the presentation begins, let me tell you how this invited speaker will run the presentation. The session will be divided into 2 sessions. Firstly, all the invited speaker will present the material for about 10 minutes each. Then, following that, we will have question and answer for approximately 30 minutes, and then finally, the session will be ended by conclusion. So, first of all, okay, I will invite, okay, ladies and gentlemen, without further ado, now let me to welcome Dr. Yusra Miza from University Utara, Malaysia. Let me read brief CV, curriculum vitae of Dr. Yusra Miza. She is a Professor Madya in SOL, University Utara, Malaysia, UUM. She had certificate of UIEM, UKM, and Doctor Falsafa from Lancaster, United Kingdom. Is it? Okay. She got many awards on Anugerah Buku Negara 2023. Is it? Okay. Anugerah Pengajian Tinggi as the Best Book Award and many other awards which has been got. Wait, okay, this one, paper is leaking. Yeah, then, okay, I just want to show you one more. This is about her achievement. This is in some of the position, right? You have many position, reputable position in your UUM, right? Okay, now I will give Dr. Yusra Miza to present her topic about considering drug use, rethinking criminal justice approach for 10 minutes, Ibu. Time is yours. I limit the time. Okay, 10 minutes for you, Ibu.
Okay, thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Very good morning.
Waalaikumsalam warahmatullahi wabarakatuh.
Especially to the moderator and the Honorable Rector, Prof. Dr. Sharif Hardi, and also the Vice Rectors and the professors, especially Prof. Dr. Mustafa and Prof. Edar, my the Honorable Professors and also the other lecturers, docents. So thank you very much for having me. So I will be presenting while I'm standing. Is that all right?
All right.
Okay. Maybe we are going to refer to the slide that I have created. This is my today's topic for the presentation, cascading drug use, rethinking the criminal approach. So this is particularly with regard to the criminal justice approach. So next. So I tend to believe that everybody will be having the similar thinking that this drug use is a social and also the moral problem. So many around the world will be regarding this drug use as a social and also the criminal justice issue. So at the same time, so we have known that this particular drug use has been controlled under the prohibition-oriented policy. So that many countries, including your country, Indonesia, and also my country, Malaysia, have adopted this prohibition policy, meaning that drug use and also the other activities with regard to this drug are totally banned and prohibited. So we are not tolerating the drug use and others. Okay, next. So having considered the important philosophies behind this implementation of this policy, we are having deterrence and also the other philosophies, which is abstinence philosophies. So meaning that for this drug use, we are going to implement the punishment and also the other criminal sanctions and compulsory treatment for drug users and also the drug traffickers. Why? Because we are applying the deterrent philosophy. We want to deter the society. At the same time, we want to deter the drug users or the drug abusers and the drug traffickers from repeating the same offenses with regard to this drug. Because we disregard this drug, at the same time, we have banned this drug. So having considered these philosophies, so we are going to prevent the drug use and other offenses with regard to drug. Agree? So in Indonesia and also in Malaysia, we ban drugs. But in other countries, for instance, we have Netherlands now, they have recognized drug as the recreational drug. For example, you can access the drug in the restaurant, in the cafe. For example, narcotic drug, like certain drug that will be considered recreational drug. So you can consume the drug. But nowadays, we have not yet recognized the drug, so still banned in our country and also your country. Okay? So we are observing that because of the philosophies, so we observe that there are certain punishment prescribed by the law. For example, we are having the imprisonment, we are having the compulsory treatment, meaning that the rehabilitation given to the drug users will be compulsory under the umbrella term of this criminal justice approach. So this is the punitive approaches that have been adopted for a long time in many countries, especially the developing countries. Okay, you have noted about that, right? Okay, next. So, having considered the rampancy of the offenses relating to drug nowadays, for example, we are seeing the high increase of the drug use around the world. At the same time, we have met so many cases involving drug possessions and drug trafficking. Do you agree that we are having the increase in the drug use cases? Many citizens have involved taking the drug and others. Okay? Because of that, many, especially the scholars, have agreed that there is the failure of this prohibition-oriented policy, particularly the international law with regard to this drug policy, which is the international convention, including this United Nations, Single Nations, the Single Convention on Narcotics Drugs 1961. So there is the long practice of this prohibition policy and the laws with regard to this banning of the drug. But unfortunately, many regard that this prohibition policy and law is a failure because of its ineffectiveness to control the drug use, which is rising. Okay, next. For example, based on the latest report released by UNODC, this is very important to be noted that we are seeing the increase of the drug use cases. For example, in 2021, we are having 296 millions of drug cases involving the drug use. And this is the high increase because as compared to the 10 years before, we are having the increase in maybe around 45%. There is the huge increase as compared to the 10 years ago. So now, for example, we can hear the cases on the televisions and also in the media social that we are having the seizure of the high tones of synthetic drug, methamphetamine, ecstasy, and many others. Have you ever seen this kind of the drugs? So I have involved in the drug client in Malaysia. So I have been appointed as the, the person dealing with the drug client. So we have known from their experience, they can create their own drug at their home just because of the chemical substance that you can obtain from the online platform. So it's very dangerous. So we have to be noting about this progress. Okay, next. Okay, because of this incident and also this phenomena, so many believe that we should change this drug policy. No, not to be having the prohibition policy at all. At the same time, we should ban or reject these criminal law approaches. For example, we have Thomas and others in 2023 have regarded that this kind of the criminal justice approach is ineffective to curb the repeating or this relapse of the offenders, not only for the drug use but also for the other crimes. For example, you can see there is the repetitions of the murder, kidnapping, theft, robbery, and particularly with regard to drug use. So many scholars have postulated that this criminal justice approach has failed to control drug use. So because of that, we can discover, based on the available literatures, that we have to change, particularly with regard to the law. So we have to change significantly the way we are going to punish the drug users, drug traffickers, and those who are committing the crime relating to drug. For example, the laboratory with regard to creation or producing the drug itself. Then, next. There is also the argument given by the scholars with regard to this failure of the drug treatment. Because we can see there is the relapse cases. Many drug users, many drug addicts, they have been sent to the center to have the rehabilitation, but then they have returned to their old habit, taking the drug again. So that many scholars have said that there is also the failure with regard to this compulsory drug treatment. Next. So because of this incident, so we can see the available debate with regard to these changes. So some will be saying that we must be adopting the new approaches, for example, the harm reduction approach and also the restorative justice approach, so that we can be giving the substitute drug, for example, methadone, to be given to the drug users rather than punishing them, sending them to the prison. So there are many justifications. For example, they believe that this is the public health issue or the health issue rather than the criminal justice approach, or this is the issue under the criminal justice. At the same time, they consider that this criminal justice approach is a failure because we can see the rising numbers, the amount, which is very high with regard to the drug users and also drug traffickers. And having considered the negative implication of this drug policy and law, we can say there is also the high cost consumed based on the implementation of this drug policy and law. For example, we have to pay so much for the prosecution, the police, the enforcement, and also a lots of money has to be tailored to the prison just because of the lots of drug users and lots of drug traffickers. So lots of money consumed for that particular enforcement of the law. Then, so we can see there are many recommendations with regard to harm reduction approach. For example, rather than the criminal justice approach, at the same time, we are also observing many alternative approaches suggested by the existing scholars. So what do you see? You want to have the new approach for that particular drug use and the other offenses with regard to these drugs. Next. So, like I have said, there is the debate, so that there is one group who have postulated with regard to the new suggestion, the new approach to be adopted for this criminal justice drug use or drug trafficking. But at the same time, we have to note there is also the traditional mind, meaning that we are still wanting to preserve or to maintain the traditional or the conventional prohibitionist or criminal justice approach, meaning that we should prolong and continue consistently the prison, the imprisonment, the death penalty, and also the other punishment for this particular drug use. Okay, next. Because according to them, if we are going to incorporate the new approaches, we are actually encouraging the drug use. Because, for example, we are giving the substitute treatment. We are giving the drug in order to cure the drug use. So according to them, it will be an encouragement for the drug users. At the same time, it will be reflecting your government and my government encouraging and facilitating the drug use. So this is part of the justification given. And then we are also having the group who are suggesting and advancing this suggestion. They want us to implement, for example, legalization and also decriminalization. Because of certain reasons, for example, they are concerned more on the civil liberty or the human rights. Okay, next. So do you agree that we should change our criminal justice approach? We should abandon our criminal justice approach. We should abandon our imprisonment and also the other criminal sanctions. So let's see my stand, my opinion. Maybe you can agree, we can, maybe you are going to disagree. It's all right, because we are having, the freedom to be clear about this position. Okay, next. Okay, my perspective is that we cannot restrict our preference to one particular model only, because we will be having the limitations of the paradigm of the approaches for drug use and also the other offenses. If we are going to limit our scope to one particular model only, why not we are adopting so many approaches, but under the umbrella term of this prohibitionist framework, but we can open our practice to many models so that we can have the concrete model for catering or handling the drug use and also the other drug offenses in the world, particularly in our country. Then, next. Okay, this is my last slide with regard my perception and also my suggestion. So why not we can open our room, we can adopt the alternative policy and model, but at the same time we should sustain this prohibitionist policy and the legal framework. But at the same time, we can open our basis to adopt the harm reduction and also the restorative justice approach. For example, we can allow the criminal sanction, but at the same time, we must be adopting this restorative justice. For example, we can ask the drug users to involve in the community, to serve the society. At the same time, we have to be giving their opportunities to return to their goodness and well-being so that we can adopt the other models too. So I tend to believe that we cannot just rely on the harm reduction, for example. We are going to give the methadone instead of the other treatment to sustain the well-being of these drug users. For me, it's not good because we are going to ban or reject totally this prohibitionist policy and also the law. So for that particular purpose, so it's very important to continue the criminal sanction, but we have to be creating the stages. And lastly, we have to be maintaining the abstinence, meaning that we have to ensure that the drug users should have this role and the goal, which is to be stopping wholly from drug use. So, but at the same time, we have to be giving them the time to be adopting the other model. For example, harm reduction model, giving them methadone, but at the same time we have to be putting, for example, the eventual role and goal, so that we can have this maintenance treatment. Then we have to ensure that they are stopping from using the drug, not to be maintained with the methadone prolonged. Okay, maybe parts of my suggestion have been given. Let's go to the other slide, which is the last slide for today's discussion. And next. So this, go to the back. Okay, this is my last point. Rather than adopting one particular model, rather than taking carrot, you know carrot like that can be considered the idiom for something reasonable, something nice. So rather than taking the carrot only, we must combine taking carrot and also the cane. Combine any other model that which are very useful for controlling the drugs. So hopefully you gain something from my presentation. Thank you very much for the opportunity, particularly Prof. Rector.
Alhamdulillah, thank you, Dr. Yuzamiza. Already present a very informative and comprehensive presentation. And later, we continue with the online Zoom. May I contact Ibu Nola Febriani binti Salman? Halo, Assalamualaikum, Ibu Nola. Bu Nola, are you there?
Yeah.
Yes, okay. Can you hear me well? My
Very
voice?
well.
Very well,
Very.
thank you. Thank you, Bu Nola. Ladies and gentlemen, now we are going to listen the second part of presentation. Ibu Nola Febriani binti Salman, PhD, from Muhammadiyah Islamic College, Singapore. The brief CV of Ibu Nola: she is as the director of Ermo Private Limited, Singapore, 23 until present. Is it correct, Ibu? Ibu Nola? Okay, Ibu. Okay, good. And then the lecturer of Pasca Sarjana S3 UIN Suskariau, Indonesia, 2023 until now. And then lecturer Stikom Batam, Indonesia, 2023 until now. And then lecturer Irdak Institution, Singapore, 2021 until present. Bu Nola also active in many organizations like members VV, UMM, Visiting Professor, Association, University, Muhammadiyah Malang, Indonesia, from 2021 until now. And then the member of AMCA, Associations of Muslim Community in Asian, 2021 until now. And then the member of PIMM, Persatuan Intelektual Muslim Malaysia, 2018 to present. Well, Ibu Nola, this morning she will discuss about continuing provisional education asatiza recognition scheme for the rehabilitations of Muslim prisoners in Singapore. 10 minutes only, Ibu Nola. Okay, the floor is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. Allahumma shalli ala Muhammad wa ala ali Muhammad. Thank you very much for the best moderator, Associate Professor Dr. Sri Mulyani, and my honorable to the Professor Dr. Haji Elidar Haidir SHM Home, Bunda, thank you so much. And thank you so much for the Professor Dr. Haji Detri Karya, SEMA, and also my appreciate to Rector of UIR University Islam Riau. Thank you so much, Professor Dr. Haji Saprinadi, SHMCL, and all the participants and the best speaker today. Alhamdulillah. Let me share my slide.
Ini kalian sampai jam berapa hari ini? Habis ini pulang.
Yeah, before I
Kemana
start,
ya?
before I start my present,
alah.
I have also present a pantun. What the pantun from the rector of UIR University, I also have a pantun. Because Singapore, most of them know is Semenanjung Malaya, never different with our Riau University, which is a pantun. Bismillahirrahmanirrahim. Sarapan pagi di hari Jumaat. Makan soto ayam di suwir-suwir. Izinkan saya pagi ini mengucapkan selamat kepada para seminar yang datang ke UIR. Satu lagi, ikan asap dijual di pasar bawah, kayu jati dijual di pasar baru. Dengan ucapan bismillah, terima kasih UIR Pekanbaru. Ya, Alhamdulillah. My title is for today is Continuing Professional Education Asatizah Recognition Scheme for the Rehabilitation of Muslim Prisoners in Singapore. This is for the International Conference of Law and Social Science 2024, which is talking about the population of Singapore. We know Singapore is a small country. I believe all the Riau, Malaysia, or nearby is always come to Singapore for the small country like a Singapore population only 5.92 million people, not more than 6 millions. 15.6% of Muslim in Singapore is South Asian origin. The rest is Chinese, Arab, and Eurasian communities. While the majority of Muslims in Singapore are traditional Sunni, like Shafi'i school, Hanafi school, and also have Shia and Ahmadi. But I'm not discuss about this all. Okay, I just want to show that what is the Muslim community in Singapore. Singapore city-state with the official language is English. We understand the normal when we come to Singapore using English and Malay, Mandarin, and Tamil. About religion in Singapore, 31.1% is Buddhism, 11.9% Christianity Protestant, and 7% Catholicism, 20% no religion from the 5.92 million people. 15.6% as a Muslim, Islam, 8.8% Taoism and for religion, 5% Hinduism, 0.6% Sikhism and others. This is all about the Singapore. We understand why we need the Asatizah Recognition Scheme. It's called ERS because we do have 500 Asatizah currently recognized by the MUIS. As a teacher of the Islamic studies, we need recognized like something, a license by the MUIS who can teach Islam moderate in Singapore. We do have 5,000, I think plus and minus, which is the Asatizah certification policy, of course, and professionalism of the Asatizah in Singapore has increased as well as the trust of the Islamic community toward the Asatizah. So we are, as a Asatizah in Singapore, must have the license to teach our community to let them know how we are recognized in Singapore. Asatizah is called ERS certification, consists of 2 tiers. We have 2 cluster or call is 2 groups. In Islamic teacher is called tier 1. Tier 2 is Quranic teachers. When become a tier 1, we can teach Islamic studies from the lower to the up one. Of course, when we are Islamic teachers, tier 1, we also can teach Quranic teachers. But tier 2, Quranic teachers, you cannot teach Islamic studies. You specialists in Quranic only, which is the tier different functions, which is the graduation, be it diploma, from the graduate degree, and the master degree, and also the PhD. Courses of guidance depend on the number of CPE. CPE called the Continuing Professional Education. If we have our tier 1, we must complete 30 credit hour CPE in 3 years, which is we must complete. If not, so we have to another apply for the license of the ERS. And if we are completed 3 years, we do again for 30 CPE another next 3 years. So the expired only 3 years. So tier 2 different with the CPE for the 30 CPE for the tier 1 is only 10 CPE only a year. So 1 year, and then after that they are continue again another 1 year. So this process is in the form of continuous guidance provided by ERB. ERB is Asatiza Recognition Board, who are the one who make the Asatiza recognition scheme, which is collaboration with the MUIS, Majlis Ugama Islam Majlis Ugama Islam Singapura, to Asatiza in the form of the course we held every month, which is accredited by them. Next is, of course, all the Muslim in Singapore we have under one umbrella. This is called Administration of Muslim Law Act, which is 1966 present until, and we are also under MUIS, who are under Islamic Religious Council of Singapore, 1990 present till now. And in Singapore we have mosques, like 75 mosques in Singapore, but the active of the mosques around 71. All the mosques have madrasah education for the all Muslim community, and there is asatiza who are recognized only can teach in the mosque. So why I add up the rehabilitation of Muslim prisoners in Singapore? They are organized by the FITRA. It's called Family and Image True Care Assistance Haven. The FITRA is the organization who are the one collaborate with the Asatiza MUIS, who can teach them to make them understand about religion, especially Islam. So the program was launched in 2018 to provide structured support to offenders during after serving prison sentences, so they can return to the society. So they can make it easy and come to the society as a normal, and they can understand how the basic about Islam to understand. So Pitra was chaired by the professor of Dr. Muhammad Faisal Ibrahim, previous Minister of State, previous of Minister of Home Affairs, and Ministry of State of Development. So the total of families who have benefit by the Pitra now is 385 families. 385 families, and by the Pitra, over 330 volunteers. The volunteers include a religious counselor, so the Asatiza itself. So have been recruit support current for former sponsor under Pitra. So which is the Asatiza is under the sponsor by the Pitra by the organization who are work collaborate with the MUIS. But we understand in Singapore, 9,536 on the 2022 as a prisoners, but half of them is Malay communities. Why? I think one of the reason is the one that from the speakers from the Malaysia said about drug. There is related with that. I believe that, and I agree with the Dr. Yusra Miza is about the one that she's present just now. And how is the Asatiza consult for the prisoner? Let's say they have a death penalty. So the person is 1 day per person, 1 day per person. So that means 1 day per person is one Asatiza for one person who are death penalty inmate. If there is 2 hours, they are make a group. So one Asatiza for 2 hours, deliver the message, deliver normal group inmate. They have cluster as well. So which is 3 prisons in Singapore: Changi Prison, Selarang House Prison, and Tanah Merah Prison. So all over in 5 zones of Singapore. Like today, Friday sermon, of course, one of the Asatis, the one they can khutbah, yeah, learning like learning in Islamic studies as well. There are cluster block A1, A2, A3. This is called for the group of men inmate, but different on the different with the Malay women. Different. It's called cluster A4. So women must be the asatizah for a woman as well. We cannot like cross the asatiz men go to the inmate woman, cannot. Okay, in Singapore, woman must be the asatizah for women. Men is the asatiz for men. Okay, so what is the program for them to learn from the asatiz in Singapore, especially akidah, yeah, ibadah, fikih ibadah, akhlak, tafsir, Quranic, and motivation. Of course, from the program contains practical of janajah prayer and zikir, always when they're starting, and salawat as well, and of course the motivation and the building of akhlak, because the akhlak must be important for them when they are come out to the society. That's all for my presentation today. Thank you so much for the moderator and all the speakers and the UIR, University of Islam Riau. Akhirul kalam, wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Ibu Nola, with a great and amazing topic about the rehabilitations of Muslim prisoners in Singapore. Okay, this is about asatiza doing the work, right? In the field to recover the prisoners. Is it right, Ibu? Thank you, Ibu Nola. Big applause for Ibu Nola. Thank you. Next, we go to the part of the third speaker. This is we welcome Professor Dr. Stephen Coase. Hello, morning, Professor Stephen.
Selamat pagi semuanya.
Selamat pagi. Baik. Guten Morgen, Ibu, Prof.
Morgen.
Okay, nice to meet you in Zoom. It seems that Professor Stephen Coase already stand by in the Zoom. Nice to meet you, Professor. I'm very sorry, this is a night in German, right? Okay, is it okay? It's okay, right?
Sudah jam 5.
Jam 5? Sudah jam 5?
Sekarang ya.
Okay, sedikit lagi. Baik. I want to introduce Professor Dr. Stephen Coase has been contributed a lot in UIR Law faculty since 2011, right? And he's actively and given many ideas of some talks and discussion to UIR academician. Thank you, Prof. Professor Dr. Stephen Coase, holder of the chair for private law and international business law at Bundeswehr University Munich Department of Economics and Management. Is it? That's good. Next, 2013 to 2015, temporary consultant at the World Bank, and many more of reputable position for Professor Stephen Coase. Professor Stephen Coase today will talk about evolving legal framework for supply chains due diligence in the European Union. And your time is 10 minutes only, Prof. Time is yours.
Can I have the host, please?
Yes, only 10 minutes.
The host. I need the host to share.
Yeah, just continue the presentation,
Oh, yeah.
Prof.
Okay. Bisa lihat ya?
That's clear, very clear.
Okay.
Your voice also clear.
Ya. Dahulu saya mau mengucapkan terima kasih kepada Profesor Elida Chaidia, Profesor Norman, Profesor Dietrich Karya, dan istimewa kepada teman lama saya, Profesor Safrinaldi, atas undangan hari ini. I will change to English now. My presentation is actually longer than 10 minutes, but I will make it in 10 minutes. I just want to point out some important aspects. Can you see the slides change? This is important because sometimes it stucks. Can you see the slide change?
Yes.
Yes. So if we talk about supply chain due diligence law, we talk about a very innovative aspect of the legislation in Germany. We have this since 2021. It is maybe the longest word you ever saw, Lieferketten-Sorgfaltspflichtengesetz, which means supply chain due diligence law. And this law is caring about the diligence in supply chains, as the name say, in order to enforce human rights in international supply chains, addressing German companies, enterprises with at least 3,000 employees, and then later also smaller companies. The scope is actually important for Indonesians because it can affect, of course, also intermediarily the small companies and also companies abroad, because they could be part of the supply chain. So the whole supply chain is grabbed by this law, and we will talk about later in the end about the question whether we export German domestic social standards here, which is not the case. Actually, it is only about international standards which come from UN standards and international treaties and agreements. And an example would be for the future, also for Indonesian companies, an example would be equal treatment in gender, discrimination aspects could be part of that. And so it is important for Indonesian companies and for companies who collaborate with German companies within the long supply chain. The systematic aspect of that is that we have here actually a corporate social responsibility obligation, which is legal fixed in this SCDDA legislation. So we have a legislative fixation of the corporate social responsibility, which is
excuse me,
interest
Prof.
in Indonesia.
Prof. Stephen, your slide is not shown up. Just now, yes.
Not changing.
Now it's
Okay.
off again.
I will do it in the other way.
Yes.
You see that now, legal fixation?
Not yet.
Not yet. Is there nothing to see?
Nothing, only your face.
Only my face. Okay.
Yes. Handsome face.
Then I do, thank you very much. Then I do it like this, okay? You see now, right?
Okay.
Yes,
Already
you can
there?
see it?
It's on already, yes.
Yeah,
You can see. Okay.
So companies must implement adequate risk management, preventive, remedial measures, and important is, it's not important that they are successful in mitigating risks or problems. They must make the best effort to mitigate these risks. So there is no obligation of result. This is a little bit a remedy for the companies, but you can imagine that this legislation was highly criticized because it was said that it might give a competition disadvantage for European and for German companies, especially in the world competition. Some important aspects of the legislation is the duty to organize a corporate whistleblower procedure. Very interesting. However, not conform and not compatible yet with the whistleblower legislation we have in Europe. We have the possibility that affected persons in, for example, least developed countries or developing countries can authorize German unions or NGOs to take civil law legal actions. However, these legal actions are not very helpful due to issues of the international private law. This is maybe the main reason why the European Union will make a directive on this, the EU Supply Chain Due Diligence Directive, CSDDD or CS3D. And this one was highly discussed. So we were not believing that this legislation will come in the end, because it was a big discussion between the member states whether we should have that, especially due to the problem of the disadvantage for European companies in the world competition. In the end, there was an agreement with a compromise. And this one is an important step forward to the supply chain due diligence legislations compared with the German legislation, which has to be adapted later. The targeted entities, I don't want to repeat that. You will see that later in the PDFs, you can have that. But the key point is that the legal consequences of an infringement of the human rights requirements, which are wider, also stretched to the environmental issues, will be enforceable by civil law actions. So it will affect larger firms directly, of course, but SMEs will be, as small and medium companies, will be indirectly also affected through business relationships, because within the supply chain due diligence and the supply chain, there will be the companies which are addressed directly, will maybe sort out companies which are not compliant with the duties of this act in order to mitigate the risks, the liability risk for themselves. So the most important aspect for me as a civil law expert is the civil liability, which was indeed a problem in the German legislation, because the German legislation did not make did not give a sui generis possibility to sue companies by the affected person. For example, if you have someone in Bangladesh who is affected by an infringement, he could not sue with the Due Diligence Act. You need to apply the general tort law, and this was the first problem. And the second problem is the applicability of the German tort law, because in the international private law, we would have the applicability of the place of the delict. And if something happens, for example, in Bangladesh, it would be the Bangladeshi tort law which would be applicable. And then it is not helping if a German NGO claims in front of a German court, if the German court has to apply Bangladeshi tort law. That will not help to give really a preventive aspect for the civil liability here. First of all, the due diligence under the CSDDD is just normal, like we have already in the German legislation, policy, integration, risk identification done by the companies, prevention, mitigation, effectiveness assessment, communication, remediation measures. If they infringe one of these duties, there is already a reason for liability and for legal consequences for this company, which is not overviewing the supply chain. Of course, the farther the problem is in the supply chain from the German company, the less will be the duties to control it, and the less will be let's say, the step to have a liability stadium. I mentioned there was no special civil liability claims by affected person in the German SCDDA. So not surprising that the general civil liability didn't play a big role under this law, especially because the SCDDA was not an overriding mandatory provision of the domestic law, as we have it in the 16 Rome II regulation for the applicability of the tort law of the European Union. So in that case, the German legislation would not be applicable if the international private law says the law of the foreign country where the worker is has the domicile would be applicable. So this would be a problem, and of course then it would not work. Private enforcement in the CSDDD in the European directive will be easier. We will have liability criteria on its own in the legislation. Companies will be liable for intentional or negligent non-compliance affecting rights or causing damages. Important is we have an independent proceeding, civil claims independent of regulatory compliance or industry initiatives. We have procedural safeguards. Courts can order defendants to disclose evidence if a claim is plausible, which is important because, of course, the companies will not give free the information to sue them. And there is a joint and several liability. This is maybe not so important, but general provision is the most important thing. It's a mandatory overriding provision. That means that this legislation of the member states, which have to transfer the directive into their national law, will be mandatorily applied in international case, even if the international private law gives the statute to the foreign company, to Bangladesh. So in that case, if something happens in Bangladesh, the German tort law, the German SCDDD translation into the national law will be applicable, and that is mandatory. So the public enforcement, very severe, of course, up to 5% of net worldwide turnover. So important is the question generally, and I see I have 1 minute more, maybe you give me 2. It's important, are these national, supranational compliance laws which we have internationally on supply chains, are they fair towards developing countries? This is an old discussion, and I would like to mention it very briefly, because it is said that the extraterritorial impact of these regulations, which is undoubtedly given, is an infringement, or it is even said it is illegitimate, if not imperialistic, exercise of unilateral jurisdiction unless they are conceptualized in the light of democratic inclusion. This is written by some American researcher, and so I don't agree with that. Why? Because, of course, this legislation is applied extraterritorial like many European Union legislations nowadays, but and of course it is affecting companies in third world countries, in least developing countries, in developing countries, and in countries on the level to be industrialized. But it is a question of the competition law, in the European countries themselves. This means we see international law was obviously not sufficiently effective to enforce global acknowledged human rights. So we can say that it is the right of the European consumer to know whether he has a product which is produced in an ethic way or is not produced in the ethic way. This is first of all a question of the inner competition law and the inner consumer protection law of the member states of the European Union. And it cannot be said that just because of the affection of companies, an intermediate affection of the companies in other countries, we cannot fulfill the needs of the European consumers and the European competition, that companies cannot take a competition advantage by breaking the rules of the human rights as they are accepted globally. So the opportunities and the challenges of the CSDDDs are clear. Procedural financing, it will be very expensive for the companies. It will be particularly challenging SMEs, small and medium companies. It will be a challenge for the competition, international competition, especially for European companies, but it might also improve corporate image and improve long-term cost reduction through the use of environmental friendly materials, as this new legislation is also applied to environmental issues. Now, this is all from today. Here is a short case example. We see here a worker in a Bangladeshi textile factory suffers injury due to an accident caused by factory failure to meet basic safety standards. Factory produced textile for German company. German company, however, did not monitor the working condition in the Bangladeshi factory. This is an infringement of the legislation. Applicable would normally be Bangladeshi tort law, but as it is mandatory overriding regulation, in the future we would apply the adapted German tort law, adapted to the new CSDDD, which will be lead to claim sui generis in the German supply chain due diligence law. Terima kasih atas perhatian Anda. Thank you very much. It's 2 minutes longer. I'm very sorry. It's very difficult to bring such a difficult topic into 10 minutes, but I hope you have some insight about this. This is a very new regulation. It will be. It is not yet all done, but it will come, and it will be important for the companies also in your area. So it's important aspect. Thank you very much.
Thank you, Prof. Okay, thank you, Prof. Stephen Coase already present the presentation about and it's a very informative and comprehensive presentation, Prof. Big applause for Prof. Stephen. Thank you. Next, ladies and gentlemen, we come to the fourth speaker. This is, I invite Bapak Dr. Abdul Talib from Universitas Islam Riau. A brief CV of the Dr. Abdul Talib. Now, he is as a head of International Department, Law Faculty, Universitas Islam Riau. He's also a lecturer in doctoral study program in UIR. He's active participated in the associations of teachers and intellectual property rights, and as a supervisory board of the Indonesian Bar Association, and many others of reputable positions in law. So today, he will talk about the analysis of intellectual property rights in Indonesia at the crossroad. Please welcome. Time is yours, Pak Dokter.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. First of all, I would like to say deep honor to our rector, Riau Islamic University, to Professor Dr. Haji Safrinaldi SAMCL. My deep honor also, I would like to say to Professor Detrikarya SAMA as a Director of Postgraduate, Riau Islamic University. And thirdly, my honor also to Madam Professor Dr. Hajah Elidar Khaidir as a chairwoman, the committee, International Conference on Law and Social Science Committee. And do not forget to all the participants and distinguished ladies and gentlemen, good morning. Let us meet to stand up in front of you. Of course, the committee already provided the interested topics. I choose one of them about technology. Technology itself, it relates to intellectual property rights. Exactly in the field of patent rights. The title is about the analysis of intellectual property rights in Indonesia, double dot at the crossroad. Why I choose this topic? Because I think this topic is always trending after the end of the world. What are intellectual property rights? As we show to the slide, so many branded, so many trademarks available there. It is international trademark, famous trademark. I choose this topic because in general, Indonesian society is very unfamiliar with the meaning of intellectual property rights. The following illustrations illustrate many people's misunderstanding of the word patent. For example, a group of people are watching a football match at a cave venue. Suddenly, player kick the ball strongly at the opponent's goal and managed to put the ball into the goal. What happened? All the watchers together say, "Goal! Patent!" Everybody say, "Goal! Patent!" Another illustrate. One driver trouble with his car. This car disorder. And he called the mechanic. After that, succeed. One person passed the road and also he said, "Patent." The car is already okay. Another illustrate, a composer, the famous composer, deliver an orchestra. And then after that, his intimate friend give some suggestion and discuss. We can say this: we, as your friends, are very proud of your talent and success as a famous composer. We have a suggestion so that your song creation are not stolen or infringement, by other parties, you should immediately register then so that you can get the patent rights. So, did this right? This suggestion from his friend? What does it mean, the patent? On the other hand, seen from the government point of view, intellectual property right is perceived as a single and functional concept. IPR is simply related to the provision of the law and implementing regulations. In the view of bureaucratic cycles, IPR is all about copyrights, marks, patent, trade secret, and the like, which must be implemented in the territory of the Republic of Indonesia because they are provided for under the law. Unfortunately, Indonesian position, if we see this slide, we have very few belong to have the intellectual property rights. The developing countries very independent, very dependent about technology from abroad. The developed countries, they have 60% IPRs. And our country, together with developing countries, only we have 8%. So it means we always dependent about technology with the foreign nations. I don't know until when. Nowadays, our president always proclaim always what we call support about the investment, foreign direct investment to invest their capital to our country in order to make our economic become increase. The impact of this, the government issued about the creation law, job creation law. Bahasa Indonesianya Undang-Undang Tenaga Kerja, Undang-Undang Cipta Kerja. The enactment of this job creation law, the impact of this so many 100 regulations already revised, already amendment. Also about the patent rights. We know the patent rights. The heart of this act, it is regulated under Section 20. I repeat again, the patent rights, the heart of or the soul of this act, regulated under Section 20. Under this section, regulate that the patent should implement it in Indonesia. And the second, all the inventor should employ the Indonesian worker and should transfer their technology for Indonesian company. But unfortunately, under Article 107, job creation, this change become patent must held in Indonesia, okay? But implementation patent as it mean on paragraph 1 consists on (a) implementation product patents which covers make, import or license product which given patent. B. Implementation patent process which covers make, license or import product which generated from process which given patent. Or C. Implementation patent method, system and use of which covers make, import or license product which generated from method, system and use which given pattern. So we can say in a short word, no technology transfer here, no implemented pattern here. So how the government say we should increase, we should more develop to make our people better the life. So we should do everything. But unfortunately, it is not proof. So the government have reason why this pattern not implemented in Indonesia. Because the inventor itself refused to implement the technology here and the product pattern here because make them disadvantage. So that's why the government should avoid this. In a short, it can be emphasized that not all companies applying for patent are actually interested to implement such patent. For instance, a European company which applies for a patent in Indonesia may not necessarily implement such patent by investing capital in Indonesia. The decision to actually implement a patent is usually subject to a cost-benefit analysis. Multinational pharmaceutical companies applying for a patent in a country do not always end up establishing a plan to implement the patent concerned. They only apply for patent protection in order to monopolize the pharmaceutical technology in the country concerned. So this is not proof the reason of the investor that Indonesian Patent Act infringe the TRIPS agreement. This is not proof. Conclusion. First, it is proven that the Indonesian people do not understand much about IPRs, especially patent. For foreign entrepreneurs themselves, apart from benefiting from the job creation law, there is also evidence of their reluctance to apply patent, especially for technology transfer. Second, for the government, some of them do not understand and some of them don't care about technology patent. This proven by the revision of several regulations, including patent regulation and the job creation regulation, Undang-Undang Nomor 6 Tahun 2023. From the perspective of international regulation, apart from emphasizing legal protection of IPRs, it also provides freedom for each member to formulate them while still paying attention to their own domestic interests, including paying attention to the interest of the state implementation of technology transfer. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Big applause for Bapak Dr. Abdul Talib. Thank you very much, Bapak. Yeah, Bapak Dr. Abdul Talib already gave a very valuable contribution and comprehensive information. Thank you, Pak Dokter. Next, we will go to Nagoya University, Japan. Hello, Prof. Yuzuru Shimada.
Selamat siang.
Selamat siang. Okay, Prof. Yuzuru Shimada from Nagoya University, Japan as the last speaker. So today, Professor Yuzuru will talk about law and development study as an interaction point of law and society. 10 minutes presentation, Prof. Time is yours.
Okay, thank you very much, Moderator, a moderator. So actually, I can speak both Bahasa Indonesia and English, but today I prepare my materials in English. So along with the title, topic of this international conference. Before that, thank you very much for inviting me. That this is very interesting and valuable international conference. I'm honored to be here as a keynote speaker. So, but unfortunately, due to my university obligation, I cannot be there in person. So maybe next time, I hope I discuss with you directly. Okay. So today's my presentation about the law and development study as an interaction point of the law and society. This presentation is a part of the introductory part of my lecture here, law and development. So I'm the professor of the Graduate School of International Development, Nagoya University. Graduate School of International Development is not a graduate school of law. So we are more concerned about the development issue, including the law and development. So we try to, analyze and educate the development, social, economic, or any kind of development from the direction. So, and I'm in charge of the legal aspect. So, what is the law and development? So we often discuss, mention about the law and development, even that academic journal published by the UI Faculty Hukum, that it's that Hukum dan Pembangunan, law and development. So, but what is the law and development? Maybe that one important point is that the hypothesis that there should be the relationship between law and development. Development as the type of the social transformation. So this means that the law may change or law may affect to the social transformation. This is one point. And this, in other words, that there might be the causal relationship between law and society. But it's not so clear that we have to discuss whether really and how extent there is the causal relationship really exists or not. And so, and this is one my research topic, that how to measure it. So, and another more practical hypothesis is if there is a good law, maybe this good law may cause the better development. So this is another point. So it's also, this point is further controversial because that we have to think about what is a better law actually. Now that Professor Taib discussed about the Professor Taib, sorry, I operated your name. No, Dr. Abdul Taib. Tariq that discussed about omnibus law. So, and the government said omnibus law should create more job opportunity. That's why that omnibus law is better law. And creating the job opportunity, it's also better thing. So maybe we have to think about what is a better law and what is a better development. But this better law and better development is not so obvious. This is the point. So in my class that the students have to consider first, what is the development? What is the definition of the development? And also that we have to think about what is the definition of law. So this is not so easy answer. So maybe that sometimes I try, if I have a chance to give them more longer lecture, I will discuss further. So, and in practice, that if there is any goal, that the development goal, for example, that the better job opportunity, more job opportunity, or good education, good health, etc., so that the government sets the goal 1, 2, 3, and goal N. And then that in order to achieve It's that based on the hypothesis that it must be the causal relationship between the law and society that the government, lawmaker makes the regulation, R1, R2, and Rn. So this how to say, the policy makers, policy setting for the development and the lawmaking by the lawmaker is that another part of my lecture. What better law should be made, or what is how to say, our experience in making better law for better development. So in my research, I already discussed with my students about that. But in order to achieve this purpose, that we have to, how to say, do the social survey in legal term, or in the field of the lawmaking. It's called the researching the legal facts and effects. So we have to, how to say, identify what legal facts exactly exist, and we have to try to measure the impact. So, and maybe this process is how to say, is expected to cause better development. Okay. That's why that law and development study is the intertwining of the legal study and the different disciplines, especially many social science field. And the law considered as a means of policy achievement in combination with other policy tools. So this, in my lecture, I call that this is a legislative policy for development. I borrowed this term from the Seidman et al. So, and in other words, that the law as a way to change the people's repetitive behavior and give a certain predictability in social relations through the normative language. If it is XXX, it must be YYY. So if you kill someone, you should be punished. If you borrowed money, you should return the money by due date, etc. Otherwise, that's it. So this is how to say, formula of law. It is interesting that this very simple formula, law try to change the people's repetitive behavior, which is considered as anti-development. That's why if people or the company or government took the repetitive behavior negative to the development, such as less productive, or how to say, less investment friendly, etc. So that the government lawmaker try to change these repetitive negative behavior against the development. This is how to say, framework of law and development study. For example, that I will give the one case that how to improve women's status in Japan. Maybe that improving the women's status is part of the development. So that how to say, larger role of the women must be the good thing for development. So maybe we have to research what is the actual status of women in Japan. So, and if you find the fact that the status of women in working place is inferior to men, so in this case, that we try to make the legal draft, make the law draft for changing the repetitive behavior, which how to say, keep the people, women's workers' status in the working place inferior to male worker. So by using the formula of law, this one. So by, for example, by penalty or incentive, or by another guidelines. So, and in case of Japan, in 1985, Japanese government enacted the law on equal opportunity in workplace. So this law obligates the company that must have to eliminate any discriminative practice against the women in working place, in order to improve the women's status in the working place from the recruitment, appointment, promotion, and salary and retirement, etc. So allowance, etc. So how is the effect? this is one interesting graph which shows the, how to say, working ratio of the women in Japan, comparing the in 1985 upon the enactment of this law and 30 years later, 2015. So this shows that in every generation, that the working ratio of women is increasing, so than before. So that's why that from this graph we can say that this law may this law has a positive effect or contribute to elevating the women's status in the working place. But this only one data is not enough. Maybe we have to check that the quality of their job, quality of their employment. For example, that the salary level, is there, how to say, the discriminative gap between the men and women, or how extent that the women are promoted within the company. This may be that in terms of number of the management position, like that. So maybe that we have to consider that further data, so that my student and me, that we discuss and try to gather and analyze those data. But now that I just talk about the women's status as a goal of one of the goal of development, but development is multi-definition. So that I let the student, when you say development, you have to make clear what's development you are mentioning. So actually, that how to say, the development is some people say that development is increasing wealth. If you have more money, you are well developed. But another people say that development is increasing the value other than wealth. Or other people is that how to say, growth is not a development. Maybe we have to keep the traditional culture rather than growth. So maybe increasing wealth is that just economic growth is typical. Maybe that economic growth is the main target of the undang-undang omnibus cipta kerja. But how to say, even if that many people have the money, maybe this money not necessarily make people happier. If we see that some country that there is how to say, very severe discrimination against the women, that women, that especially girls, are excluded from the opportunity for education. As a result, even though they have money, that the girls, because of their gender, they are excluded to develop themselves through the education. That's why that money is not itself. Money is not enough. Maybe we have to think about how money are spent to achieve the other value. So maybe this is called the social human development value. So, and there are many types of development, and we have to consider that actually that the development might be all positive, but actually that each development goals is that not consistent each other necessarily. Sometimes that, for example, equality and growth can be contradicting. So, and some country is that even though some country is poorer than another country, but their happiness is better than other countries. So maybe that this is we have to very carefully think about how to say what the development is, and also that we also have to think about the function of law. What function we are expecting to law? So that according to Summers, that he said that mentioned to the 5 functions: remedy for grievance among the members of society, penal instrument to promote certain defined activities, and managing various governmental public benefits, and giving the effect to the particular private arrangements. So this is maybe how you know that the first one is that how to recognizing the people's right, and the second one is penalizing the people, punishing the people to control their behavior, and instrument to promote certain defined activities, that incentive, for example, that how to say legal marriage, etc. And managing various government public benefits is that give the justification for the government behavior, government policy, legally give the justification. such as like, if government makes the law on education, maybe government has the justification to allocate more budget to the education. So, and the last one is disputes resolution. Maybe we have to combining those functions of law to achieve the various type of the development goals. And we also think about the different type of law, informal norms and informal laws. So, formal law is that especially the law, undang-undang cipta kerja, KUHP, undang-undang perlindungan data pribadi dan informasi pribadi, etc. So, but it's not enough. We have to think about the informal law, hukum adat, hukum agama, dan lain-lain. Okay. So how we combine understanding this interaction? So actually, that the informal norms is very familiar for people. People usually live with informal norms, and they are very familiar with that, accustomed to that. That's why that they, how to say, easily accept the value brought by the informal norms. If informal norms is how to say, incorporated formal formal laws, maybe that how to say, effectivity of informal norm might be strengthened. So this is one way, and the government can implement the formal laws less costly, because people already ready to accept that formal laws. If that formal law is very close to their informal laws. But the weakness of the informal norms is very traditional and slow to change and very oftenly discriminating against the minorities. So as we see that the case of the traditional custom is very discriminative against the women and minorities, and especially religious ethnic minorities. So that's why sometimes we have to change this negative aspect of society through changing the formal laws. So this is another function of the, how to say, legal strategy to change the society. So maybe this is so. For example, that how to say, maybe one Japanese, how to say, this law is a way that there is a custom of the, how to say, again the working informal norms about the working women in the Japan, but the government making the new law and try to change the, how to say, informal norms already existed in working place in Japan, which is discriminative to the women. So by making the informal laws and imposing obligation to the companies. So this is another, how to say, function. Okay. So, and in my class that I always discuss that we have to think about the interaction between the formal laws and informal norms. So, and using the informal norms is very effective and less costly, but in order to change the society drastically, maybe we have to be, how to say, brave enough to make the new laws, such as, how to say, allowing the gay marriage in the Taiwan and other countries. But in Japan also that is controversial. Or in Indonesia, for example, that recently that the government make that, how to say, undang-undang kekerasan seksual, tindakan pidana kekerasan seksual. Itu juga itu. It's one way to change the society by the formal laws. Maybe my class in law and societies, maybe I hope that this very brief introduction in my class may contribute to the discussions in this international conference. Thank you very much. I'd like to return the mic to the moderator.
Yes, thank you, Prof. Shimada, for the presentation. Big applause for Prof. Shimada. Arigatou gozaimasu, Prof. Shimada, for your speech and your presentations. Now, we come to the second sessions of our seminar. Invited speaker. There is a question and answer that will be given to the speakers. Okay, student, all the audiences, ladies and gentlemen, if you want to ask the question, please stand up, mention the name and the speakers number 1, 2, 3, 4, or 5, and then you raise the question. Okay, we start. Yeah, okay, stand up please. Stand up. Yeah, okay. Any microphone with you, lady?
Assalamualaikum warahmatullahi wabarakatuh. My name is Aprilia Dwananta. I'm from Faculty of Law. I have question for this Professor Kim Hyun So. So there are currently ongoing topic on ownership and authorship on AI generated content. For example, there is actual exciting robot that does household jobs. If, for instance, the robot committed crime as to kill the owner, how would the law respond to that? Thank you.
Okay, April, you may send the question to Bu Eni, and Bu Eni will forward to me to give to Prof. Kim.
Okay.
It's much better rather than writing. Prof. Kim cannot hear clearly because it's quite far. Okay, Ms. Prof. Kim, you may invite it in on the stage, please. Yeah. Okay, thank you, April, for all the question. The first question from Aprilia to speaker 1. Invite the speaker, Prof. Kim. Yeah, how does the legal, what is it, April, just now? How does the legal, how does the laws?
If, for instance, the robot committed the crime as to kill the owner, how would the law respond to that?
Okay, can you get it, Prof. Kim?
There are currently ongoing topic ownership and authorship on AI-generated content. For example, there is an actual exciting robot that does household jobs. If, for instance, the robot committed crime as to kill the owner, how would the law respond to that?
Your very nice question, but I don't this your question is an answer. How about your robot in an AI in this century? Do you have a robot? Do you know robot in to AI?
Yes, if the robot committed crime to kill the owner.
Yes. I think that the robot murder is not act. Robot is not act in a criminal law. So recently is not permit. Permit is not permit. So I think that change the criminal law and in the future. So maybe it's a robot murder is very bad robot. Yes, maybe we are not permanent is not in the law is right now, but we have to we can pursuant to in the future. I think so. Okay, you right?
Okay, thank you, Prof.
Thank you so much. Yes.
Okay, thank you, April. Next question, I think I collect. Yeah, please stand up. The lady at the left side, do you have a microphone with you?
Okay, my name is Diani Putri Ramli or Diani. So I have a simple question for Prof. Kim Hyun Soo. I'm sorry, I'm so sorry, Prof. So I think about artificial intelligence is most popular topic, I guess. So my basic question, like mostly problem in social life, like our life, social life behaviors, is not connected about cyber security. But most topic I curious about Prof opinions is the form of EA has also become one of most popular of many benefits that are very useful to increasingly advanced life, but it turns out something like has also been explained earlier, like occurrence of crime from like negative things about a monthly benefit for human for our social life. So my question is, how your opinion, Prof, like how to stability of EA and humans in social life, like mostly in cyber security, in new global era condition right now. Thank you, sir. Thank you, Prof. Sorry.
Excuse me. Yes. I check your question and translate it to in English, right? Just a moment. Did you have some?
No, I don't have. But this is about the cyber.
Yeah.
The cyber for the future. The negative one, although these are benefit, but there is a negative from AI and cyber security.
Okay.
For the future, how to prevent it?
Yes.
How to deal with it?
Yeah. Yes. AI is very, very important program in this century. Yes. AI is not come to here, but AI is coming here because we are a start and AI in the world. So cybersecurity between cybersecurity and AI is very important program, but AI and cyber security is connect, and we have important. Anyway, so right. I think that is very important. So we hope the development to the AI in order to AI world. Maybe I'm sorry. Yeah.
So, I just wanna curious about your opinions about EA, because we don't know, right? Like EA, like life becomes easier.
Yeah.
Like so sometimes we cannot to take our like myself, like because I have because I can use EA, so we think is all we can do is with EA. So
Yeah.
I just curious. Thank you, Prof.
Yeah.
About opinions like how to stable like EA and humans in social life. And
Okay.
thank you for your answer, Prof.
Oh, thank you.
Thank you.
Yes.
Sorry, what's your name? Just now.
Diani Putri Ramli, Fakultas.
Okay, thank you, Diani, for the question.
Yes.
Is it okay, Prof Kim?
You
want to add more?
No more.
Okay, no more.
If you want to more answer, give me by email. I send you my name card. I finish this seminar. Yeah.
Yes, another question. Please stand up and mention your name. Yeah, stand up. Okay. Do you have a microphone with you, lady? No, okay, that's coming, that's coming.
Assalamualaikum warahmatullahi wabarakatuh. First of all, I want to introduce myself at first. So, my name is Kanaya Vina Valeri, and I'm from Law Faculty. This question especially is for Professor Stephen Klaus, he's not here, so I thought maybe Professor Kim can answer this question too.
But I am here.
Are you okay, Mr. Kim?
I'm sorry. So my question is, how can businesses effectively implement the CSDDD to ensure ethical, environmental, and social responsibility throughout their supply chains? Thank you.
Yeah, actually we don't know yet, yeah. So we have a very short experience with that in the last years. As you see, this legislation is very new. It is a very novelty legislation in the world. We have separate legislations. For example, we have legislation in the Netherlands for Kinderarbeit, for children work, and so. But this one is a very comprehensive legislation, and it is not for nothing very high criticized, because we don't know how we implement it. What we can say is we need a pragmatical approach to implement that. So we have the concept of the organizational duties, of organizational guilt. And organizational guilt in big organizations, this is why I'm very much interested in that, is in the European tort law and the German tort law. If you have a big company or a concern, yeah, you cannot await that the CEO knows everything what happens in the lower end. So, but you can await that the CEO is organizing the structures of the companies in a way that it is that it can be visualized, that it can be controlled, that it can be avoided special issues. So we must differentiate between issues which are organizational issues, so organizational failures and other failures, and that will be the challenge for this legislation, which is very strict in the results if there is an infringement. So how companies will do it? It will be maybe easier for bigger companies, because the bigger companies have maybe more manpower to do these things. Smaller companies will have a problem to control it, but as you see, the supply chain can be very long. For example, we have a German company which buys products from let's say Poland, and Poland orders products in Indonesia, and Indonesia orders the raw material somewhere else and produce it then in somewhere near Jakarta. So how can we control what happens in the end? What happens in the tin mining, for example, in Bangka? Yeah. But we have a general knowledge about that. We have a general knowledge that in Bangka, of course, there is the official tin mining, and there's a lot of unofficial tin mining, which might destroy the whole region if it comes to the poisoning of the water and so on. So will this general knowledge be enough for an infringement? This will be a question, right? So this is difficult. And also we have the problem that even if we have international agreements about human rights, the idea about what should be human right infringement and what not can differ. Yeah. So, for example, if I talk in Indonesia about oil plantage, palm oil plantage, yeah, then we can say, okay, there is an international interest in the climate protection. But if I talk in Indonesia about that, then they will say, well, it is our existence. We exist from this, yeah. So we want to be more pragmatic. So the question of the pragmatism in certain countries is not the same like in other countries. And if you forbid certain aspects, then it would be maybe a problem for the existence of the people living there. So this is all very difficult. It will cause cost, yeah, and it might be that will be a big competition problem for European companies. But they will have to follow it, because if they not follow it, that could be for the public procurement, for example, a problem. Because, for example, the German government cannot maybe give a contract to a company which infringed this human rights interest in the supply chain. So we don't know yet how to enforce it. We don't know yet how to do this, but my personal opinion is there will be more pragmatic enforcement and more pragmatic approach than it is in the theory. So in the theory, it can be very strict, especially if we combine it with the whistleblower legislations. Yeah, anybody can make a whistleblowing and can denounce a company which infringe that and can say, well, our company knew about the problem in the supply chain, in the lower end of the supply chain. But in the end, I think there will be sort of pragmatic way how to handle that, and I hope this pragmatic way will not be that pragmatic that the purpose of the law cannot be fulfilled at all. So this is my answer to this. You see, it is not very clear how will be the future with that. The companies are very critical. The companies are very much afraid. They must start now to implement it, and that will be difficult. But the same happens with the AI regulation in the European Union. It's the same issue. We have a good theory about ethics, and we have a good theory about what we wish for the world, for the development, but we have also the idea that the pragmatism sometimes win, and we don't know whether we will enforce the ethics in the AI regulation in the European Union in that way as the regulation plans to. So there will be, in the end, pragmatism, because we cannot stop the development, right? So this is my answer. Thank you very much for your interesting question.
Okay, thank you, Professor Stephen Kors. Okay, Nana. Okay, ready? Is it clear?
It's clear, ma'am. Thank you.
Clear. Okay, thank you, Nana. Okay, I invite one more question because we limited the time. One more question, raise your hand. Okay, stand up please. Mention the name.
Baik, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Perkenalkan, nama saya Dharma Yulani dari Fakultas Ekonomi dan Bisnis Prodi Manajemen. Baik, adapun pertanyaan saya ada untuk Prof. Yuzuru, yaitu di Indonesia itu ada yang namanya hukum tidak tertulis dan hukum tertulis. Nah, sedangkan di Indonesia itu hukum tidak tertulis adalah yang dinamakan dengan hukum adat. Dan saya ingin bertanya kepada Prof. Yuzuru itu bagaimanakah sistem di Jepang? Terima kasih.
Prof. Shimada, are you there? There's a question for you.
Terima kasih banyak atas pertanyaan.
Okay.
Sangat penting dan fundamental. Okay, bahasa Indonesia, because that is the Professor Stein, that's from Germany. Nice to meet you. So, and let me speak in English. I miss your name. What is your name?
Dharma Yuliani, Prof.
Norma Yuliani.
Okay, Norma. So,
Norma.
Yuliani, thank you. Norma. Norma. So that you are question about the hukum adat in Japan, or hukum tidak tertulis in Japan. In fact, of course, there are hukum tidak tertulis, or in other words, customary law, especially the traditional customary law in Japan. But different from Indonesia, this customary law in Japan is not recognized as a source of law as a formal source of law in Japan, especially in the litigation. So, but the example of the hukum tidak tertulis or customary law is, for example, that the community ownership, communal ownership of the land, especially in the forest, mountain, or the river, or lake, and etc. So, and also that sometimes that you know that how to say, right to fishing, or right to hunting or collecting some resources, nuts, mushroom, or wood from the forest. So maybe those are mainly customary law in Japan. So And as I said, those customary law is not recognized as a source of the formal law in Japan. But if there is any conflict about that, the parties can can submit the existence. Some things parties can claim the existence of that kind of the customary law in the court as supporting evidence. And a court may evaluate those, customary law as evidence. It's the free discretion of the judges. So, and another difference between Japan and Indonesia is that because in Indonesia, the customary law is very, strongly preserved. So, but in Japan, along with the historical development, that most of the customary law disappeared and converted to the modern law, modern ownership. For example, the communal ownership of the land is already converted to the individual property. So, as a result, so that maybe in Japan it's a bit difficult to find the case of the customary law, but in fact it exists. I hope this is my answer for your question. Thank you.
Thank you, Prof. Shimada, for the answer. Norma? Norma, are you okay?
Oh, okay.
Terima
kasih, Prof.
Yeah, thank you, Norma. Next, one more. This is I invite from Zoom, right? There is one question for Ibu Yusra. Ibu Yusra? Hello, everyone. Good afternoon. My name is Dr. Chi Hui Bing from Malaysia. My question is forwarded to Dr. Yusra Mirza. I'm impressed with her lecture to indicate that drug addiction is a sickness. My question is, what are the key legal challenges faced by drug rehabilitation centers in ensuring compliance with both medical and legal standards? This is for you, Ibu.
Thank you very much for the question tailored by Dr. Chi Hui Bing from Malaysia. So this is the medical doctor, right? Okay, with regard to drug use, I tend to believe we should consider it not just solely disease problem, but at the same time we have to be noting this kind of the issue as the combined social, criminal, and also health problem, so that the important approaches should be given to this particular issue is that the combined approaches. So having considered the existing rehabilitation approach implemented in the rehabilitation center and also the supervision in the community, so the entities or the agencies dealing with these drug users will be facing multiple problems. For example, just because of the community of the, in the bracket comma, community of this drug using population is very rampant. At the same time, we have the high availability of this market for drug. So especially for the countries near to the Golden Triangle area, and we have also the challenge involving, you know, the synthetic drugs. It's very easy to be produced at the same time, just because of the challenge of the corruption too. So irrelevant to that particular challenge, so we need to see that this problem is escalating, but at the same time, maybe some of the drug use and also having considered the drug users during their rehabilitation, they tend to believe that they are undergoing the punishment. But actually this is not the whole punishment, but we have to be considering the other modalities implemented therein. But some of the drug users, they have not removed just because of their, you know, dependent not to be treated solely or wholly and significantly with the any medicine, because we have not found the specific medicine for treating drug users. But at the same time, we are finding maybe it's the substitute drug, for example, methadone and others, just to preserve the well-being of that particular drug users. But at the same time, we need to ensure they are going to cease from that particular drug using. So what is the important challenge that must be considered is that they have the limitations of also the manpowers to ensure the compliance of the drug users whenever they are stopping from the rehabilitation. Because out there are big challenges. So maybe subsequent to their treatment in the rehabilitation center is all right, but coming to the subsequent stage, they are going to be exposed to many challenges out there. So having considered the limitations of the manpowers, officers, even in Indonesia and also in Malaysia, we have faced this problem, the limitations of the enforcement officers for ensuring the compliance of the drug users for certain procedures and others. That's my humble opinion. Thank you very much for the question from Dr. Chris.
Thank you, Dr. Riza. Doctor, okay, from Zoom is okay. Now I come back to the Zoom question. Okay, this is from Frankie. Yeah, Mr. Frankie. I would like to ask question for Dr. Nola. Dr. Nola, are you there?
Yeah.
Yes, okay. One question for you. How to measure the effectiveness of Muslim prisoner rehabilitation involving asatiza? How to measure the effectiveness of Muslim prisoner rehabilitation programs involving asatiza?
Yeah, thank you so much.
Yes.
The question just now?
Yeah, one question from Frankie for you, Dr. Nola.
Thank you. Okay, Bismillahirrahmanirrahim. Thank you, Frankie. How to measure the effectiveness program involving the asatiza? Okay, first of all is why the asatiza, why we need to consult them. Okay, first of all is we want to make it the asatiza professionalism in Singapore, of course, and to measure that effectiveness program is, of course, the program being by the MUIS itself, who collaborate with the ARS itself. ARS is Asatiza Recognition Scheme, which is the inside is ERB, Asatiza Recognition Board, the one who choose the Asatiza who can consult the prisoners. So most of all the prisoners in Singapore, there are half of the 9,000 just now is Malay communities. If we are talk about the Malay, automatically some of the automatically is related with the Muslim community, so they need consult by the asatiza. But of course, if we see the effectiveness is effective about that is not at all, because some of them after they come from the prison, I mean they go back to the society. Some of them they go back again to the prison again. It's because of the environment, of the stressness, and make them make it like they are comfort zone there. They're afraid to come up from the prison. But of course, as asatiza, we need to strengthen our community to make them how to say untuk mereka mampu beradaptasi, bersosialisasi lagi, keluar dari tempat yang mereka rasa sudah nyaman begitu. Dan kadang ada salah satu yang pernah di interview ya, Dia bilang dia tidak kenal environment lagi gitu, apalagi dengan zaman yang sekarang, sehingga dia merasakan lebih baik kembali. Nah, sebagai asatizah, we need them to realize, okay, world change, education change, environment change, okay, about the sustainability. So we make them open their eyes, open the mind. So of course the program that we are giving to them, and also consult them to make them confident, to make them trust themselves. So as a society also, we are like kita membantu gitu ya. Kita membantu mereka untuk mereka bisa keluar secara independently. Kalau tentang efektifnya, hampir rata-rata ini ada salah satu grup. One of the group is called Anissa Group. Anissa Group made by our asatizah Ustazah Laila, who have a center in Singapore. So from when the outcome out from the prisoners, no more inmate, so they make it a community. So when they have a community with them, support each other, you know, so they have their own role model asatizah. So they want to change. They want to change. They can see, you know, the change, the effective of the asatizah make them confident to go into the society again. If we are talking about the percentage, of course, hardly for me to sit there, but hopefully I can ask for the one who are direct with them. Sometimes I also replace for the asatizah who can teach them as about the religion, you know, every Friday night. So there are curiosity about learning about Islamic studies, everything's about it. That's all. Thank you so much. Maybe enough?
Okay, thank you, Bu Yona, for the questions. Ladies and gentlemen, this is the last question and answer because time is already up. Now Ibu Dr. Yuza, Pak Dr. Abdul, Prof. Kim, please give applause, Prof. Stephen Kos, Prof. Yusra, and Dr. Nola. Big applause for the keynote speaker and invited speaker. Then this is the last session that I will invite again for Ibu and Bapak to return to the seat. Then we will close our sessions of invited speakers. Please, Bapak Ibu, Prof. Yeah.
I'm sorry to interrupt, but maybe all the speakers can hold on for a moment because we have another session to give the plug to all moderators and also the speakers. Yeah, in front of the stage.
Okay,
thank
here
you.
in front of this one. Okay,
yes.
Thank you. I return my mics to the MC. Thank you very much for today. See you another time. Wassalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh.
Terima kasih. Sampai jumpa.
Okay, terima kasih. Izin live.
Okay, we would like also to invite the moderators itself from the previous session, Associate Professor Dr. Sri Yuliani SPD MPD to coming into the front of the stage, and also directors of Universitas Islam Riau, Professor Dr. Syafrinaldi SIMCL to present the plaque to our three keynote speakers. And the first plaque is giving to Professor Kim Hyun-soo from Ina University, South Korea. Okay, we can give a big applause to Professor Kim Hyun-soo from Ina University, South Korea. And on the next one is Dr. Abdul Talib SIMCL from Universitas Islam Riau. And also for our moderators for today's event, Associate Professor Dr. Sri Yuliani SPD MPD. And also to the speakers, to one of our keynote speakers, Dr. Yusamiza from University Utara, Malaysia. And also, we would like to move on to our next event that we're gonna give a special reward to Chief Executive of ICoLSS 2024, Professor Dr. Elidar Haidir SH MHum, to coming into the front of the stage, and also the rectors of Universitas Islam Riau as a host, Professor Dr. Syafrinaldi SH MCL. And we also would like to invite the postgraduate program director, Professor Dr. Detri Karya SAMA, to be presented the special reward to the rectors of Universitas Islam Riau and also to the Chief Director Executive of the event ICoLSS 2024. Okay, now one is a photo session of to the all the keynote speakers that come into the Universitas Islam Riau, and also to the with the rectors, Chief Executive of the ICoLSS 2024, and also the director of postgraduate program of Universitas Islam Riau. And we also want to invite the vice rectors of Universitas Islam Riau to coming into front of the stage to having a photo session together with all the keynote speakers, rectors, postgraduate directors programs, and also the chief executive of ICoLSS 2024. Okay, thank you so much to all the speakers, rectors, postgraduate, directors program, and also chief executive and also moderator of previous event from the seminar. Please give big applause to all the VIP that coming into in front of the stage. Thank you to all the distinguished guests who have attended the opening of the International Conference on Law and Social Science 2024. Our next session will be featured presentation from the participant starting from 2 p.m. and so on. In the meantime, you are welcome to perform the Friday prayer and also to enjoy the refreshment provided to all the audience that invited. On behalf of the organizing committee, I'm Dwi Suprafli. Thank you so much for coming for today's event and bidding for you to farewell now. Thank you so much. Assalamualaikum warahmatullahi wabarakatuh. Hadirin sekalian yang kami hormati, bagi laki-laki yang hendak untuk melaksanakan sholat Jumat, kami persilakan untuk dapat berangkat ke Masjid Al Munawwaroh, dan untuk perempuan yang